Shalom again, Israel. This is part two of the mortgage crisis, foreclosure, bankster scam. Well, like we have said in part one, the banksters are nothing but a bunch of thieves. They're a bunch of criminals, but organized criminals. Okay? I mean, they do this thing all the time, all these racketeering. And even when they get caught, as you know, seriously, nobody goes to jail. Nobody almost ever goes to jail. We heard about the five major banks who were busted the other day for a lot of these robo signing and all of these frauds that they were committing. Okay, it's nothing new. Well, there's a famous case known as the Credit River Decision, December of 1968. It was one Mr. Jerome Daly versus the bank, Manhattan Bank. Now, this is what happened in this case. Mr. Daly, being a lawyer himself, was behind on his mortgage and owed the bank allegedly a few couple $100. So they decided to file a lawsuit, a foreclosure lawsuit against Mr. Daly. Now, Mr. Daly did the right thing in which he required a trial by jury based upon the Seventh Amendment of the Federal Constitution. That is very important. The Seventh Amendment states clearly, quote, in suits at common law where the controversy is over $20, the right of trial by jury shall be preserved. End of quote. So Mr. Jury, he invoked the Seventh Amendment right, in a civil case to get a trial by a trial of jury. Now this is what happened. And when the day came, Mr. Jerome Daly went and he testified to the court and to the jury that the bank did not loan him any money, not a penny. And he explained the process, which I said in part one, where you sign a promissory note. The bank took that promissory note, opened an account for you, deposit the amount out of thin air into the account, goes to the Federal Reserve, loan back the money to you, securitize it, etc., etc. Now, what Mr. Daly did, he subpoenaed the bank manager to come on the stand and testify, and the bank manager agreed that what Mr. Daly said is standard practice for the bank. The jury didn't need to hear much more. They, of course, obviously ruled in favor of Mr. Daly. Check it out. It's called the Credit River Decision of 1968, Jerome Daly versus, I think it's the Bank of Manhattan. So the point what we're saying here is this fraud is known for a long time. Okay, they don't lend you any money. They cannot lend you any money. They do not lend you any credit money. It's against the law. This is under 12 United States Code. Now, one other thing you need to know is this. One other thing that we use to bring the banks to their knees, okay, is this. There's a thing known as the Truth in Lending Act, okay, known as for short an acronym TILA, Truth in Lending Act. And there's a section of it known as the R.E.S.P.A, Real Estate Settlement Procedure Act, chapter 2605. What this act does, it states that the bank must disclose to the alleged borrower full disclosure, everything pertaining to the loan, which the bank does not. Okay, the bank does not do that. And one other thing we do in the tiller, we send them a RESPA letter asking them for certain documentation that prove that they have standing to collect our money. Now, like I explained to you in the securitization and a lot of this fraud, they cannot produce a lot of this documentation, so they are in trouble. So oftentimes when that happens, what they do, they kind of start to bend over backwards to you, meaning they start to offer you modification. Yep, modification, and they start to work with you when they see that you know what you're doing. The TILA, Truth in Lending Act, is very serious. The RESPA is very serious. Let me give you a Supreme Court ruling upon the RESPA. This is one. It states, quote, a violation such as not responding to the TILA rescission letter, no matter how technical it has, no discretion and respect liability, holding that creditor failed to make material disclosure in connection with the loan. Title 15 of the United States Code, 1605. Wright versus Midpen, Consumer Discount CO. Okay? So the tiller letter, the RESPA letter is very, very powerful, okay, because it asks the bank to produce a lot of documentation, which is a catch 22 for them because if they reveal the truth, you'll see the fraud. And if they hide the truth, then you can turn around and sue them for not fully disclosing or responding to your letter. And they have a certain time to respond to it, okay? So that's one of the things that we use to kind of like bring them to their knees. They do not want you to know this. Another thing too is, like I said, 99% of the loans, alleged loans, were securitized, where they take the note, turn it into bond, and sold it on Wall Street. This is in violation of the Security Act of 1933, okay, because they securitize these loans without the borrower's knowledge, without them having any idea that they're doing this, and they destroyed a promissory note, a negotiable instrument, without the maker of the instrument knowing. These are all UCC violations. Okay. Another thing too that we do, a lot of people don't know about it, is um, for example, when you sign any loan, for example, speaking of mortgage, you have 3 days to rescind the loan, meaning the creditor is supposed to give you two forms per person. If it's one person, it's two forms. If it's two persons, it's four forms. This is by law. Okay, this is under the tiller law, where they have to give you two forms each. If they don't, and this form, what it does, it gives you 3 days to rescind. Like, let's say you see things in it that you don't agree in this alleged loan, you could rescind it within 3 days, get back your money, and everybody's, go their merry way. However, if they do not, you could sue them, or you could now have within 3 years to rescind that contract. Okay, so you have, instead of 3 days, you have 3 years to rescind that contract, and the law is very serious. You could hit them with some hefty lawsuit. If And let me tell you this: a lot of mortgage company did not give the people these two rescission forms. Okay, if they did not give you those forms within 3 years, you could rescind it, get back your money, or you could sue them. Another thing that the banks are supposed to do, they are supposed to give you a thing known as a holder in due course notice, okay, which is CFR 433.2. Every credit application, the alleged borrower must have this form. Must. It's the law. And I could guarantee you, a lot of you did not receive any such forms. Okay. There's a lot of violations, but the banks get away with it because people don't know. And sad to say, most, not all, but most attorneys, they will not help you because they are officers of the court. They do not want to upset the apple cart, so to be. They will not bring a lot of these facts into the court because this could bring the whole thing down if people find out what's going on. So they tend to play with the game because they're officers of the court. So a lot of them won't reveal these things. So I'll do one more video after this. Shalom.